private of places a bedroom in the home, unquote. Kennedy also invoked the Due Process Clause of the 14th Amendment, and in her concurring opinion, Justice Sandra Day O'Connor invoked the Equal Protection Clause. Thus, in 2003, the Supreme Court not only had overturned the Hardwick ruling, it set the stage for full equality for LGBT citizens. More states began to legalize same-sex marriage, including California. Professor Kevin Johnson, the research director for the Center of First Amendment Studies, will now tell you what happened next and discuss the implications for the future. Kevin?
I'd like to thank you all for coming out this evening in celebration of our Constitution Day. The Constitution works in mysterious ways. It is active, contested, messy. We like it when it's convenient to our political ideology, and we negate it or try to get it to say what we want when it's not convenient to our political ideology. This process is the way ideas are contested in democratic deliberation. Sometimes constitutional issues make their way to the Supreme Court with blazing speed, while at other times the path takes much longer. The recent cases involving same-sex marriage took a long path before reaching the Supreme Court and may take even longer before being entirely settled. The purpose of my presentation today is to share with you some of the complexities involved in the constitutional debate over same-sex marriage. I've organized my thoughts today into two sections. First, I'll explain how same-sex marriage entered the court system to begin with and share the major rulings in the recent cases. And then second, I'll explain why the core of the constitutional contest over same-sex marriage appears to be about whether homosexuality is something that people are or something that people do. In doing so, I'll explain a First Amendment framing of the constitutional arguments that may be the already given equal protection arguments in the public sphere. But let's begin how we got here in the first place. It's important to note that same-sex marriage has not always occupied a privileged space on the LGBT rights agenda. In 1993 and 1994, the LGBT movement was preoccupied with legislative fights over employment discrimination, housing discrimination, Bill Clinton's Don't Ask, Don't Tell policy, along with moving forward on a whole lot of other different kinds of ordinances. The national movement in the early 1990s seemed focused on other priorities than same-sex marriage. Meanwhile, out in Hawaii, 3 same-sex couples filed for marriage licenses in the state. They had met every legal requirement for the state's recognition of marriage, except for being of the same sex. Hawaii's Department of Health, who issues the licenses, consulted with the state's Attorney General, who asserted that under the Constitution, the right to marry is fundamental, but only for different sex couples. The Department of Health denied the marriage licenses, and the 3 couples filed suit against the state of Hawaii in violation of Hawaii's Constitution. In 1993, Hawaii's Supreme Court required the lower court to demonstrate a compelling state interest for denying same-sex marriage rights. So the legislature reacted to that by forming a commission to study whether there was a compelling interest. Then in 1995, the commission recommended that Hawaii extend open marriage to same-sex couples. What this did was that it sent shockwaves through the Bible Belt of the United States. More conservative states began to fear that they would have to recognize Hawaii's marriage in their own states. As a result, anti-same-sex marriage ordinances began spreading throughout the United States. And as a result of that spread, the LGBT movement was forced to shift its focus away from its national agenda of gaining protections against key items like employment discrimination, of which there is still no federal protection, and toward countering the anti-gay ideology embedded now in the anti-same-sex marriage arguments. So they were drawn into this particular argument. So throughout the 1990s, same-sex marriage went from an issue relatively low on the LGBT movement's agenda to arguably a central place in today's movement. So where are we today? There's two important cases that I'm sure that you have all heard about that have been recently decided in the Supreme Court. These involve the Federal Defense of Marriage Act and California's Proposition 8. So first I'll talk briefly about the case of United States versus Windsor, which had to do with the Federal Defense of Marriage Act. In 2007, two women who were residents of New York married each other in a lawful ceremony in Ontario, Canada. Edith Windsor and Thea Spire returned to their home in New York City after their marriage. When Spire died 2 years later in 2009, she left her entire estate to Windsor. As a widow, Windsor sought to claim estate tax exemption for surviving spouses. She was barred from doing so because the federal DOMA law, which excluded a same-sex partner from the definition of spouse, as that term is used in federal statutes. So Windsor, what she did was paid the taxes, but filed suit to challenge the constitutionality of the provision. The case recently reached the Supreme Court, and the court ruled, quote, this is from the majority opinion, DOMA singles out a class of persons deemed by a state entitled to recognition and protection to enhance their own liberty. It imposes a disability on the class by refusing to acknowledge a status the state finds dignified and proper, end quote. So there are two important things to note in this ruling. The first of which is that the ruling does not say that same-sex marriage is the constitutional right of same-sex couples. It carefully explains that a state, in this case, the state of New York, has the power to determine what recognitions and protections are necessary to enhance their own liberty absent a compelling federal government interest otherwise. And second, the ruling is confined to those couples that are legally married already. In other words, because the state of New York recognized the marriage of Winslow and Spire, the federal government could not overrule that state recognition at the federal level since there is no interstate conflict involving the federal interest. Thus, the court left open the right of states to determine whether or not they wanted to recognize same-sex marriage, or at least deferred the decision until much later, where we haven't been yet. The second case that we're all much more familiar with maybe is Hollingsworth versus Perry. After the California Supreme Court held that limiting marriage to opposite-sex couples violated the California Constitution, state voters passed a ballot initiative that many of us are familiar with, Proposition 8. The proposition amended the state constitution to define marriage as a union between a man and a woman. What then happened was a somewhat bizarre path to the Supreme Court. Same-sex couples who wanted to marry filed suit in federal court challenging Proposition 8 under the due process and equal protection clauses of the 14th Amendment. And it named as defendants California's governor and other state and local officials responsible for enforcing California's marriage laws. However, in the case, the officials that were named refused to defend the law. So instead of the public officials defending the public law, the district court allowed the proposition's official sponsors, a private party, to intervene and defend it. So when it came to the Supreme Court, the court ruled that it is unconstitutional for a private party to represent the public in federal court. In other words, only public officials are able to defend the public in federal court. And because they did not do so in this case, Proposition 8 would be upheld as unconstitutional because the state did not levy a defense. Okay? Again, in this case, I think there's a couple implications that are drawn from it. The first is that a precedent was set that public officials are able to refuse representing the democratic will of the people. Regardless of your feelings or your feelings about this on this particular political issue, the precedent is set that public officials may veto future constitutional amendments in the state of California because they don't want to defend whatever the amendment is in federal court. so they can just refuse to be defending the constitutional amendment that the people passed. And the second implication is that since Proposition 8 was effectively overruled, it left the previous California Supreme Court ruling intact, such that same-sex couples may marry in the state of California. Okay? The second one was much more focused on for obvious reasons. So having discussed the landscape of the constitutional cases, I'd like to turn to an observation about the state of constitutional debate as it currently exists on same-sex marriage. Thus far, our national debate over same-sex marriage has been primarily framed in terms of equal protection clause and due process arguments. These arguments are rooted in the idea that sexual identity is something that comes to define what people are. Those opposed to same-sex marriage and the equal protection argument, however, are inclined to believe that sexual identity is defined by what people do. Thus, those unpersuaded by the Equal Protection Clause argument argue that the Equal Protection Clause is for protection of people as they are and as they were born, not for protecting the sexual behaviors of what people do or choose to engage in. In other words, they remain less convinced of a gay gene, potentially, and more convinced that being gay is a behavior. Thus, from that ideological perspective, the Equal Protection Clause arguments are not all that persuasive to some, okay? I believe that there's a different and potentially a more persuasive path than those Equal Protection Clause arguments that have been advanced thus far. One need not concede the Equal Protection Clause argument in order to imagine this different path of constitutional argumentation. Specifically, I would identify two paths that remain untraveled and under-researched when it comes to constitutional law. Specifically, I think it's possible to frame same-sex marriage as a fundamental right concerning the freedom of expression, which is the Center for First Amendment Studies issue. There are at least two ways to make such an argument at the outset. The first of which is that one could argue that it is viewpoint discrimination and a violation of the freedom of expression guaranteed by the First Amendment. In other words, no attorney has ever opened their oral arguments in a court of law with a quote that would go something like this. I'm not a constitutional attorney, but it might sound something like this. Mr. Chief Justice, and may it please the court, when a woman stands in front of a justice of the peace, she may express her love and lifelong vows for another person only if that person is a member of the opposite sex. She cannot express her love and lifelong vows for a woman of the same sex, and that is viewpoint discrimination in violation of the First Amendment of the United States Constitution. Opening up an oral argument, something like that. So this is based on a reciprocal expressive institution to which you would then have to demonstrate a compelling government interest to be able to restrict the expressive right. The second reason that I think that the First Amendment is implicated here, and it's potentially even more important, is that marriage is a symbolic institution. It is a public declaration. It is not a private ceremony. In fact, the entire national controversy is over the meaning of that symbol and what it ought to mean. The fact that it is a symbolic contest may be evidence of it being a type of symbolic expression. Denial of a marriage license is fundamentally a denial of the symbolic expression that comes with the marriage license. Marriage is a political act, and political expression is at the heart of First Amendment protection. So now, I'm not sure that these arguments would resolve the debate, but at least I think it would garner a little bit more complexity when we're talking about the constitutional arguments that are at a stalemate when it comes to equal protection and due process kinds of arguments. Although that debate is unlikely to end anytime soon. The purpose of my Constitution Day talk was to share with you some of the complexities involved in the constitutional debate over same-sex marriage. I did this by highlighting some of the constitutional issues, as well as the issues involved in the recent Supreme Court decisions, and by offering some more complexity regarding the possible First Amendment questions on the subject. Freedom of expression is at the core of our democratic society and enables lively debate on this issue. Out of the marketplace of ideas, hopefully we are equipped to agree that the marketplace is one where all ideas may be offered, even while some are perhaps less deserving of being purchased. Information and the expression of ideas is the currency of democracy. And while I might not be the biggest fan of market metaphors, I am a fan of the freedom of expression as a fundamental right in a rich and vibrant democracy. And so, as we continue our contest over same-sex marriage in the United States, may we also pause a little bit on our Constitution Day to remember the Constitution's role in getting us into this messy debate, and to remember that democracy is messy, but in my view, very much worth the mess. Thank you for coming today.
Before we get to some questions from you all, just a few things. First of all, I'd like to introduce one of our big supporters. The Dean of the College of Liberal Arts, David Wallace, is here, and we appreciate all of your efforts on our behalf. You can also go online to the Center for First Amendment Studies. It's at www.firstamendmentstudies.org, very easy. And there are lots of research papers on various First Amendment issues that you can use in class and cite and so on and so forth. Don't plagiarize them, just cite them. And there are a couple of ebooks on the First Amendment and religion and the First Amendment and the media. So I invite you to go to that website. We've done a lot of different things at the Center for First Amendment Studies that have included forums in the city of Rome in Italy on these issues. We've taken students over to Rome, where we have an affiliation with John Cabot University, an American university there, where Kevin and I have taught for several years. And we have also been able to establish contact with some members of the Supreme Court. Justice Alito came to John Cabot University, and we were able to have dinner with him in a private conversation to get his take on certain things. And Kevin has visited the Supreme Court and the chambers of Justice Kennedy. So we have been talking to these people, and we think we know where they are coming from. We've also written a book with a chapter on each of the justices on the Supreme Court.